Time being 11:45, I'll go ahead and bring this meeting to order. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call.
Swenson. Healy.
Here.
Kettering. Los.
Here.
Commsion.
Here. Again, Commissioner Kettering is still in the hospital as far as we know, and I'd just like to take a few moments and pray for a speedy recovery for him. So we'll take a few moments just to think about Commissioner Kettering and send him some prayers. All right, thank you very much. All right, do any of the commissioners have a reason to abstain for financial or non-financial conflict of interest at this time?
Do not.
I do not.
No.
Okay. All right, next item on the agenda, item number 4, approval of the agenda. Entertain a motion to approve the agenda.
So moved.
I have a motion, is there a second?
Second.
I have a motion and a second. Further discussion? All those in favor say aye.
Aye.
Opposed? Motion passed. Next item on the agenda, item number 5, public comment.
There was one listed at Mr. Rayup.
Welcome, sir. Come on up, state your name for the record, and we'll give you 3 minutes.
Ray out. Good afternoon, commissions. I would like to recite some lyrics that were penned about 187 years ago. My country, 'tis of thee, sweet land of liberty. Of thee I sing. Land where my fathers died, land of the pilgrim's pride. From every mountainside, let freedom reign. Samuel Francis Smith penned that in 1832. As you render your judgment this day, may it be with balance of mind, with openness and fairness to all.
Thank you. Anybody else care to make a public comment at this time? Was that the only one
That
written
was-
down there?
yep.
All right, seeing or hearing none, go ahead and close public comment. We will wait to go into Board of Adjustment. State's Attorney is on the way.
So moved.
Second.
I have a motion and a second. Further discussion? All those in favor say aye. Aye. Opposed? We are now in Board of Adjustment. We're going to go over the format for the meeting real quick. It'll be the same as before. We're going to have 10 minutes for the complainant case. Now, this is a combined time for all the complainants, so if there's more than one, it's 10 minutes for everybody. That's going to be followed by a 20-minute permit holder's case, followed by a 20-minute complainant rebuttal. That's going to be followed by a 10-minute permit holder rebuttal, and then at the end, we're going to have 30 minutes for the Board of Adjustment to ask questions and have discussion. Is everybody okay with the format?
Yes.
Yes.
Right. Yep, go ahead, make a copy. Okay, this time, item number 6, we're going to have an appeal hearing for J Cuts Building Permit 3431.
Mr. Chairman?
Yes, did you want to come address?
I-
All right, I'll give you 5 minutes. Yes, come on up.
Mr. Chairman, members of the commission, my name is Todd Wilkinson. I'm from DeSmet, and I appreciate the opportunity to be here today. I just want to bring up a procedural issue at the outset. I have,
Thank you.
understanding that Commissioner Kettering is hospitalized and unable to be here, I am making a motion to have Commissioner Swenson recused, or a request, I should say, to have Commissioner Swenson recused as a result of bias. Can I expound on that a little bit?
How much time does he have?
4:30.
Yeah.
Okay,
Go
thank
ahead.
you.
You can use the whole
All right,
4
I don't think
minutes.
I'll go that long.
Sure.
So I would just reference for the commission's information, the commission is in a quasi-judicial process. That's what the court of the Supreme Court of South Dakota has indicated what this process is. So as a quasi-judicial process, you can't bring any fixed opinions that are not susceptible to change. I would direct your attention to a binder that I'm going to file with the auditor, and that binder would note that Mr. Swenson has previously been determined to have bias against hog operations on 3 prior proceedings before this board, and you voted that he was not able to be impartial. I would also note that since then, a number of additional posts have been placed on social media, which clearly indicate a bias, and I'm filing them for the record with this body. And it would be a violation of my client's due process rights if a board member is allowed to participate with a preconceived bias. And if you proceed with him in the participation process, our Supreme Court has determined under Armstrong versus Turner County Board of Adjustment that will then render your decision subject to being tossed out, and we have to go back through and do this all over again. If Commissioner Kettering was here, this wouldn't be such a big issue, but it's now a big issue because if Mr. Swenson is unable to participate, that only leaves 3 commissioners, and my threshold burden to meet for my client is 4 votes. So procedurally, I'm not able to even obtain the possible vote, and because of that, I filed a request last night for a request for a continuance from this. I would renew that request, and again, I would renew my request that Commissioner Swenson be recused as a result of bias. Thank you.
Thank you. Gary, do you feel you could make an unbiased determination in this case? Thank you. All right, I'd entertain a motion on, does anyone mind to make a motion to recuse Gary? All right.
What, I'd like to ask Mr. Swenson a question. I guess he's written that he has no comment, but you've said in the past, Commissioner Swenson, that you filed a report with the sheriff's office with a confrontation with Mr. Cutts, and you asked that a restraining order be put in place. Do you feel that that action will influence your vote today? I move that Gary, we have Commissioner Swenson recuse himself from the proceedings for Mr. Cutts' hearing.
I have a motion. Is there a second? Motion dies for a lack of second. All right, at this time, we'll go ahead and have a 10-minute complainant case holder. So if there's any complainants, now we'll open it up for 10 minutes, and I remind you, this is a 10-minute combined time for all complainants. Commissioner Loest will be keeping time.
Good morning. I shouldn't have trouble meeting the 10 minutes. I struggle to introduce myself yet again, but I'll do it differently this morning. My name is Phil Taw. I'm retired Air Force, despite my two commissioners on the board who served in the Army, which I'm sure they regret, but I want you to know that I did receive a Bronze Star with Valor in Desert Storm on the ground with the Army, supporting you and your comrades. So, all jesting aside, that's who I am. I live in Gayville. On November 8th, 2018, a CUP for a 2,400 head hog finishing confinement was granted to Mr. J. Cutts. That was after about probably 8 or 9 months of changes and hearings from beginning in January, February of that same year. On December 12th, the building permit was issued. That building permit 3421 expired 180 days after that from December 12th on June 10th of this year. A request for zoning enforcement was submitted on October 19th, with a couple others submitted a few days later that month. Excavation on this site began on or about October 19th, with no other visible above-grade construction performed before the expiration of that permit 3431. The CUP and the building permit for this site approved the construction of 2 curtain barns and not 1. The site plan for these 2 buildings was referred to in the minutes from those meetings from the Planning Commission, but not included in any of the documents provided here or at the time of the hearings, and I've been unable to locate them. I'm not sure if Mr. Vedder has them or not. Complying with that site plan is also at issue here today. These are the dates and the facts relevant to this case. So, at a minimum, Section 1723 of our ordinance regarding site plans, Section 1725 regarding permit expiration, Section 1727 regarding construction and use as applied for, and Section 2303 regarding the penalties and enforcement for violations all go directly to your authority and responsibility to take action and make your decision today. Thank you.
Thank you. Would anyone else care to speak as a complainant at this time? How much time is left?
7:30.
7 minutes and 30 seconds. Now would be the time to do so. All right, seeing and hearing none, I'll go ahead and close the complainant's case. And now we will move on to a 20-minute permit holder's case. Welcome, sir. State your name for the record.
Again, my name is Todd Wilkinson, and I'm here representing Mr. Cutts in this process. I am going to ask my paralegal to pass out a binder to each of you, because I think it's going to be easier to just kind of follow along in the process here. And at the outset, again, I want to note from the record, because apparently Mr. Swenson has laryngitis and is unable to verbalize. I'd ask that the auditor note that he responded no comment on a written form when Commissioner Loest asked if he could be impartial. I don't know, absent that would get in the record, and I want to make sure that it was in the record. So I would, as part of this, I would renew my objection to the board proceeding with a commissioner that's exhibited clear animus and bias towards my client and the hog industry in particular. So I'm gonna jump through this process, and I'm gonna start off right off the get-go with Section 1725. And, you know, if you look at Section 1725, you guys have...
Sir, where are you at in your binder?
Okay.
So we can follow along with you.
It will be 22.
22. Thank you.
You guys have probably looked at section 1725 ad nauseum in all of these proceedings, but I think it's relevant and it's critical to look at the plain language of your ordinance does not say that a conditional use permit expires. It simply doesn't say that. Now you can say that it's in the caption, but if you look at your section 2303, and I didn't put that one in my binder, did I? Section 2303 of your very own ordinance.
Do you have the page for that, or?
I will get your page number of your ordinance.
It's 141.
Okay, 141, thank you. It specifically says that subtitles don't control, they're not law. So you can't look at a subtitle and put any weight in it. So, I'm sorry, it is on page 21 of my binder. So, it would be Bait Stamp Cuts 85. Subtitles appearing in connection with the foregoing sections are inserted simply for convenience to serve the purpose of any index, and they should be wholly disregarded by any person, officer, court, or other tribunal in construing the terms of the provisions of this ordinance. Okay, so that being said, nowhere does it say a conditional use permit expires. So I'm gonna start with that. Now, we certainly have an issue of whether the building permit, because it clearly says a building permit can expire. The building permit would expire according to your language. The building permit shall expire if the work, and I know you've heard lots of discussion about the term work and what work encompasses. Again, and I know you, and I don't mean to be repetitive, but I have to make a record. So the term work is not defined in your ordinance. So then we have to go to common definition. And common definition is going to be under any of the dictionaries, I would submit, is going to allow for not just physical above ground work, but work you did in preparation for a project. So you have to construe the language in your ordinance according to the common usage. So, and I'm going to point you to Morris Communications versus the City of Bresmer City Zoning. That's tab 24 for your information. And I'm also going to reference tab 25, and that is Weaver versus Cleary. Again, I'm not going to go all the way through the sites, but I would submit to you that those two courts have clearly defined that work is not above ground erection necessarily of a site. But you know, even if we go into your interpretation of work, the fact is Mr. Cutts constructed a mortality bin, and the bin was constructed before the 180 days was ever up. And interestingly, in your very minutes on October, this is tab 6, on your meeting, it specifically notes that this is the October 9th, 2018 meeting. Now, I know some of you weren't here. It specifically notes that a mortality bin was required as part of this project. And so Mr. Cutts constructed a mortality bin just as you required. That construction is work by anyone's definition. So then we go to Mr. Cutts and what else he did, and I'm just going to ask Jay to come up here because I want to make a record and have him confirm what I am submitting to you is correct. And there's not enough room there, I'm chasing everything around. So, Jay, you were granted a conditional use permit by Yankton County, correct?
Yes, I was.
And after you received the conditional use permit, you applied for a building permit.
Correct.
And you received building permit 3231, correct?
Yes.
And you filled out the information on your portion of the building
On the
application?
application, yes.
And you posted a permit sign, a building permit sign on your site as given to you by the zoning officer.
Yes, that's correct.
And the handwriting on that was by the zoning officer.
That's correct, yes.
And can you characterize, these guys they already know it better than anybody, given what you went through with water down here, but I gotta make a record. What was the condition of Yankton County in March, April, May, and June of this year in terms of roads, flooding?
It was very wet with a lot of roads closed, a lot of road closures all over. This site was basically the only way you could get to it was from the west, and not very well at that. As a farmer in Yankton County, I could only get into plant maybe 80% of my fields. And this was one of them that was is a lower area, and it never did get planted on one side of it.
And again, I'm gonna be quick with this. Can you tell me how much time I have now?
Oh, yep, 12 minutes.
Okay. Just to go down some things that you did, and this was submitted to Mr. Vetter as part of your response, and we'll note the place on that in a minute, Mr. Chairman, but you made a down payment to Ethan Lumber and MDS Manufacturing,
Yes, I did.
and that was before the expiration of the 180 days from the issuance of the permit.
Yes, it was.
And you also contracted with Quality Well,
Yes, I did.
and that was before this date.
That's correct.
And that was to do what?
Dig a well and bring water into the facility.
That was the water for your site.
Correct.
And then you also contacted Terry, is it Schramm?
Schramm, correct.
Now, I understood that was significant because I assume most of your roads were going to pot down here because of the water. So you wanted to make sure you had gravel availability?
I wanted to make sure I had gravel availability for construction and also the driveways and roads, yes.
And did he reserve gravel for you?
He stated to me that he would reserve gravel and make sure I had enough, at least 75 loads of gravel, correct?
And the dates that you contacted him, those are reflected in the document you filed, correct?
Yes, they are.
So the document you filed is a correct representation of steps and work that you did.
Yes, it is.
In addition to that, had you spoken to a lender to line up your funds?
Yes, I'd spoken with the lender to line up funds to do this project.
And you had a site plan prepared by an engineer for this project?
Yes, I did.
And who was the engineer?
The engineer was Nick Rao out of Jackson, Minnesota, Pro Ag Engineering.
So all of those steps you did prior to the expiration of the 180 days?
That is correct.
And tell me about this mortality bin. What is that?
Mortality bin was placed out there in the approximately correct spot with 4 posts that were put in holes in the ground, and fence panels were screwed to those posts, like my other facility that's operating correctly right now.
So your existing operating facility has an identical mortality pen?
Yes, it does.
So this is the type of mortality pen you were putting up for that purpose?
Yes, it was.
All right. So, thank you.
Okay.
So, for the record, Mr. Chairman, my paralegal has submitted the binders, and I believe you all have them. I would just ask to note that my binder is being received in evidence in this hearing.
Yes.
Okay, thank you, Mr. Chairman. So, given the demonstration of work, and that work was done, I want to point out a couple of other things that are rather peculiar. On the building permit, which is tab, not only my paralegal, she's my daughter, so this really helps, let me tell you. On the building permit, which is tab 8, I just want to reference you all down to the bottom corner where it says building permit number. See where it says 3231? I would ask, and then I would go to Exhibit 9, right after that. Again, this is filled out by your zoning officer at the time. He wrote 3231. Now let's go to tab 10. Now this is how your records appear today. And I would ask you to note the building permit number. Now we don't have access to your records in terms of changing records, but clearly somebody has doctored the books on this building permit number. And I will tell you that through your notice process, you used the wrong number. You used 3431. So the notice for, in fact, one of the complaints that you got even says that Jay was using the wrong permit number. Jay was using the right permit number. Somebody in the zoning office changed the number. And then it led to a complaint against Mr. Cutts. Now that's a pretty good indication of some bias going on and some improper activities. I don't see that change in that number being inconsequential. I see it being deliberate, because if you compare those two numbers, you can even see that there's been a change to the second one. It's very visible. And I submit to you, if I had access to the original one, we could even make it more relevant. The Exhibit 16, which is your notice of this very hearing, is not correct. So it says building permit number 3431. We're not here in building permit 3431. We're here on building permit 3231. So your notice is defective. In fact, Mr. Vedder's findings in his letter is defective. Now, I don't have an explanation as to how that changed, but somebody should. I will also note that when we requested records, and the records that were submitted up for this appeal, Mr. Vedder's job is to submit to you the records that are in the file. That's what your appeal notice says. He's to submit the entire record. We have a site plan that was submitted and approved by your then zoning officer that isn't in the record. Where that went, I don't know. In fact, the complainant that came up here noted that. We'd like to know where that went. We know that there are some documents that reference a building site, and there's also another document in here that specifically has the words mortality bin written over it. I would submit to you that that's coming up in your file, so that's part of your record. We can't write on those documents. We can't take things out of the file. Somebody has. And when you're the ones that are in control of the record and changes are made and records are missing, that's your burden, not the applicant's. I would submit to you that Mr. Cutts has fully complied with what he was required to do. So there's, as I noted, no explanation of those documents. And I know you've heard the issue about your 2006 zoning ordinance not being properly adopted. I'm going to reference that for the record. That's up, and I would agree with Mr. Peterson, that's up for a judge to decide whether it was properly adopted. You have to work off of what you have today. I fully understand that. But I will submit to you that it is our position that that is not properly adopted. And if the court determines that, not only is the conditional use permit still outstanding from the one you issued, there isn't a reason to have a conditional use permit because it wasn't required under the 2003 ordinance. So, again, I'm not going to belabor the work. I would submit to you that our demonstration of work is ample, and I also have a question, and frankly, I haven't researched it to know whether I'm right or wrong. I'm just raising it as an issue. In your November 15, 2019 minutes, Exhibit 15, it says that you appointed Mr. Vetter as Development Services Director as acting zoning administrator. So that's the date that you appointed him with the title of zoning administrator, and you made it retroactive. I don't know how you make an appointment retroactive. And I would submit to you that the reference of trying to make it retroactive makes his actions up until the date you formally appointed him completely void, because he lacks authority as a zoning administrator. So, ma'am, can you tell me how much more time I have?
Sorry, you have 3 minutes.
So for the reasons that, number one, we did work. Jay Cutts did work. He doesn't have to put the building up. It doesn't say he's got 2 years, or 180 days to complete the building. It gives him 2 years. Once he starts that work, you don't get to arbitrarily say, this work isn't good enough, this work isn't good enough. And then and because of that, it causes me concern, and maybe it's just because I've been doing this too long. When Mr. Vetter issues a letter on October 24th that says a complaint's been filed and he investigated the matter. I don't know about you, but the term investigation to me means taking some action to go out and interpret the facts. I would submit to you that Mr. Cutts was never interviewed, was never asked to supply any information, was never asked to substantiate his position between the October 21 and October 24. Now that's like making somebody the judge, jury, and never giving the other side to have due process. If you were treated that way, and all of a sudden it's an identity investigation, wouldn't you naturally come back and say, but don't I get to have input? Don't I get to even put my side in? He didn't. He didn't get to put it in. That's not even possible. You can't make an investigation without actually doing something for both sides. Again, submit to you that's clear evidence of bias. And the other thing that's most glaring in this, thank you, I know that you have some other cases that had complaints filed in July. I would submit to you that if you look at the complaints on this case, none of them were even filed until October. There was no complaint on this site until October. So how is Mr. Cutts supposed to know that he has any problems with his site? I'd reference Exhibit 11, tab 11, that's where your complaints are at. I don't need to put in any more about the road conditions. You guys know your road conditions. I would just submit to you, commissioners, that let's have an unbiased, fair review of Mr. Vetter's actions. And I would submit to you, you need to repeal his action because there was no investigation and there wasn't even an opportunity, to review all of the evidence. Thank you.
Thank you.
Oh, I did well, didn't I?
Perfect.
Cut it real close. So. All right, next, okay, now we close the permit holder's case, and now we'll open it up for a 20-minute complainant case rebuttal. And again, this is for all complainants. So 20 minutes. Is there anybody who'd care to speak? Welcome.
Thank you. Phil Toggan, I'll do my best here to address some of the concerns, Mr. Wilkinson. Regarding the bias of Mr. Swenson, we all have bias. Mr. Kettering has bias. He voted for the last 2 years on every barn, no restrictions. So he has bias. He just doesn't put it out on Twitter and Facebook. I'm not going to stand here and justify anybody's actions, or Mr. Swenson's in particular. But it is what it is. And what happened last week was an illegal vote. We all know that. We found out how that's supposed to happen, and his rights were violated to represent his constituents. What he does about that, I can't say, but it had to be 4-1, not 3-2 like it was. Okay? We can go round and round about that one. I'd like to submit a letter from our council, Mr. Peterson from Sioux Falls. It's generic in nature about
Thank you.
some of the issues that were raised in the last couple of hearings and again today. And I'll summarize some of that now.
I'm gonna,
Regarding 1725 and how you want to...
Mr. Tell, I'm going to get some copies and hand them out to
All
the
right.
commission, if that's okay. That way we can follow along with you.
Sure, no
It'll
problem.
be just a moment.
Okay. I'll be referencing packet numbers as posted on
Okay,
the county website versus whatever
thank you.
the applicant gave you. Okay.
Thank you.
On page 2, he starts off and he talks about the council recently has suggested that the zoning administrator and the Board of Adjustment lack the authority to deem conditional use permits expired when the permit holder failed to commence work within 180 days. This argument relies on a narrow and strained reading of 1725 of the ordinance while ignoring the rest of the ordinance. Section 1725 plainly applies to building permits, conditional use permits, and variances that are not diligently acted upon by commencing work that is in the building permit within 180 days. They have argued the board should ignore the plain language of the entirety of 1725 because entities other than the board are precluded from utilizing section headings or titles. Section 2403, not 2303, prohibits people, officers, courts, or other tribunals from making certain determinations regarding the headings. However, 2403 places no such restriction on the Board of Adjustment, which makes sense in light of our legislature's mandate in South Dakota Codified Law 11-2-61.1 that boards of adjustment have broad discretion in interpreting the ordinance, which interpretation is binding on a reviewing court. Additionally, other sections of the ordinance allow for the determination that unused permits may be deemed expired. Under 1727 of the ordinance, a landowner's use, arrangement, or construction at variance with that authorized shall be deemed a violation of this ordinance and punishable as provided in 2303 of this ordinance. Here, the CAFO owners are constructing facilities or using properties in a manner not authorized by the county, which is punishable under 2303 of the ordinance. Section 2303, which is triggered by unauthorized construction or use, provides a broad range of remedies and powers for the Board of Adjustment. If a building is constructed in violation of the ordinance, or if land is used in a manner not permitted by the ordinance, the zoning administrator, quote, the zoning administrator may institute any appropriate action or proceedings to prevent such unlawful construction or use. 2303 plainly allows the zoning administrator to determine building and conditional use permits have expired when they are not used as authorized by the county, and that the zoning administrator may institute appropriate actions or proceedings accordingly. This plainly includes determining such permits have expired due to non-use within the permitted time frame. Section 2303 further authorizes the zoning administrator to prevent the occupancy of a building constructed in violation of a permit or the ordinance, and to prevent use in or about such premises where a violation has occurs. This is precisely the actions taken by the zoning administrator when he determined the building and conditional use permits in question were expired. If their counsel is correct, conditional use permits last forever, even when not used in a timely manner. That has never been the policy, the practice, the ordinance or law in Yankton County, and it should not start now due to a strained, narrow, and selective reading of one particular section of the ordinance. The zoning administrator and relatedly the Board of Adjustment have authority to determine building and conditional use permits are expired when the permit holder fails to commence work within 180 days. The Board of Adjustment's determination in this regard is further entitled to deference from any reviewing court under 11-2-61.1 of codified law of South Dakota. It was mentioned here today that you have to construe the ordinance and 1725 by the words in that paragraph. That may or may not be true. You have great latitude to read the whole ordinance and what the whole ordinance intends, and I've just gone over that. And the latitude given you by the legislature under 11-2-61.1. The mortality bin, if you reference, I believe, in packet 5, page 22, you'll see a picture of that mortality bin. It is neither permanent nor fixed. It looks like pallets stacked up by the road with a building permit on it.
What page are we on, Mr. Taylor?
Page 22 of packet 5. And probably too close to the road. I didn't measure the 75 feet right away. That was granted as a variance in this permit. Okay?
Is that the structure the building permit is stapled or taped to?
If that's what they're referencing. I don't know what the structure is behind that. There's neither new or clear what that is. Okay. Regarding the permit number, permit 3431 is what's on the form. It's a sequential number that the county uses. The ones issued the previous day ended at 3430 on December 11th. I'm sure 3431 was the next day. If you look at packet number 1, page 8, issued on 12/12/18, it says 3431. It may or may not have been changed. I have a copy as well as you do. I don't know. But if it was changed, it was changed by Mr. Garrity. There's no conspiracy on our part. There's no bias on our part to have this changed. That's what's recorded as the building permit number. And we can argue that all day. Okay? It may or may not matter. There's plenty of typos throughout the county planning and zoning minutes. Okay? Yankton, let's see, the job title argument. When was his, I would ask, when was his date of hire and what job did he get hired for? And if you change the job title later to make sure it included other duties as refined as you want him to continue. He is the zoning administrator. When he started, he was the zoning administrator, and he's fully within his authority. I don't care what job title you give him. Okay, that's what he was hired for on his hire date, and that's what he did. All right? Yankton planning minutes on October 9th, 2018. Again, this is a probably 3 planning missions combined into one from September into October, as well as back from February. On page 3 of that document,
What packet are you in?
I'm going to reference the Yankton County
Sure.
planning minutes.
Okay.
I don't know if they're in the packet or not. They should be somewhere. The October 9th, 2018 minutes. Jay Cutsford stated he revised site plan which meets the property line setback requirement and a right-of-way variance to be out of the floodplain located on the property. The proposal is two curtain-style barns as shown on the site plan exhibit number 3 and number 3A, not in the minutes, not in the packet. I don't know what that would be. The site plan needs to include the mortality bins before the building permit will be issued. It's also referenced in the commission meeting notes that approved the CUP. What's being constructed right now is on the edge of that floodplain, and by all the pictures I've seen and one I took the other day, it's one building, not two. I don't know what the future plans are, where he's going with that, but there are high walls to accommodate for the floodplain on the east side. And there's plenty of pictures in your packet, number 4, I believe. Now let's make it packet number 3, about the flooding from this year. The only site plan picture that I've seen that's qualifies as a site plan is in packet 4 on page 9. And that's the original one building barn that he needed a variance for from Mr. LaRue Hansen, and he did not receive that permission from his neighbor for that variance of 75 feet. Okay? So, in conclusion, some of their arguments don't hold up to me, don't hold up under some reason with what the ordinance says and what the actions are taken. This county has had a long discussion beginning in May through June and into July about extensions and reapplying. And this board on June 18th made a clear statement, come on in, talk to us, and let's get this handled. Whether it's an extension or whether it was a reapplication, we want to help you figure out how to do this. And they didn't come in. To the best of my knowledge, I don't know if he came in, okay? The letters in the packet that Mr. Wilkinson submitted that were on Jay's behalf were in October, so they knew. It was all part of another packet. The ordinance being out of date or under threat of the 2003 ordinance or 2006 being invalid, that's exactly why we need to do temporary zoning controls, and I can go into detail about that. But I spoke on that yesterday, and I think you're moving in that action with 11-2-10 of the South Dakota Codified Law, and that's what we need to do to settle some things down here and move forward. So with that, I'll conclude and just say that the work hasn't been done as in the building permit with 2 barns. It's something completely different. Dates and what work is. It's up to you to decide how you want to interpret your ordinance, not what anybody else does, not what a dictionary says, not what some other court says in some other state or some other county. This is Yankton County's ordinance, and you are the board that authorizes and interprets that zoning ordinance. Thank you.
Thank you. How much time do we have?
7.
We have 7 minutes left. Would any other complainants like to have rebuttal at this time? Right, seeing and hearing none, I'll close the complainant's rebuttal, and now we'll move on to 10 minutes for the permit holder rebuttal.
Thank you, Mr. Chairman. First of all, I want to ask Jay to come up here because an issue's been raised, and that is the change in the buildings. So can you address how that was handled?
After my building permit, I continued to talk to Mr. Hansen to see if I could change the site of the building over against his property line. And at a certain point in time in this discussion, we finally came to an impasse and said, you know, we're not going to get the variance. I'm going to, you know, build a hog barn, you know, 660 feet away from his property line. In talking to industry manufacturers and industry people around, I said, you know, can I do this better, or is there a different way to do this? And how would be the best way to utilize this site? And it came up with a single building which moves it out of the floodplain further and away from my neighbor further. So I said, okay, if I can build a 2,400 head barn like this and it gets me out of the floodplain and away from my neighbor, I'll do it. So I went to my engineer and got a site plan and submitted that to Mr. McGinnis. And I said, okay, we're gonna move from 2 to 1 barn. We're just gonna stay at 660, and it'll move it out of the floodplain and into away from my neighbor. And he said, well, both of those are good things. He said, and as long as you're on the same footprint with the same number of animals, he said, let me consider it. And he
I went back in and talked to him later, or I had a phone call with him. I don't remember which one it was. And he said, as long as you're in the footprint and the same number of head, that building change was acceptable. Now, I submitted a site plan to him, and he said it was acceptable. I took him at his word at it as the zoning administrator at the time, and I expected that to be put into my file. And it's just like any other house building change plans or whatever. As long as you're within the footprint and don't change things like that, it's usually allowable. And he said that was okay.
Thank you, Jay. I just wanted to get that clarification because that's where the holder of the records, the controller of the records becomes so relevant in this case because, and contrary to the argument that was put forward about the number not making difference and they were dated correctly, they simply aren't. That was a clear change. And there's no reason to make a change unless it's for some biased reason. Because when a complainant comes to you and uses the wrong number and says that Mr. Cutts used the wrong number, how is he supposed to do that? He's got the building permit that was issued to him. He's simply trying to act in compliance. I want to go to the tab 23, and I would submit to you that, you know, we're talking about these cases all being not South Dakota, not South Dakota. Well, the fact is, tab 23 is the South Dakota case, and it's Peters versus Spearfish Planning Commission, and I would reference bait stamp 88. That's that little thing down the bottom, kind of like a page number. And I would reference the last sentence of the standard and scope of review. And I'm just gonna, that would be right here, guys.
Got it.
Okay. When interpreting an ordinance, we must assume that the legislative body meant what the ordinance says and give its words and phrases plain meaning and effect. That's a law of the state of South Dakota. You don't get to change that. So let's go back to Exhibit 22. Exhibit 22 is Section 1725. Doesn't say anything about conditional use permits. Mr. Peterson is flat wrong when it says that you have broad discretion to make something up by the scope of your ordinance. That is flat wrong. You cannot get to go out and make up new limitations because the public's never had notice of it. If the public doesn't have notice of your ordinance, you can't make it up and say conditional use permit ends in 180 days because that's what we've been doing. That's simply not the law. You don't have that discretion. And then I found it interesting when the comments were being made about you're supposed to come back and reapply. Mr. Cutts did that. Go to tab 28. He went in and reapplied. Same building application. Comes back in and gets the letter, which is the one that's tab 28. That's Cutts 119 bait stamped. And he was denied the new building permit because the county has taken the position that 1725, the building permit and conditional use permit has expired. Well, if you look at what his October 24th letter says, that's Exhibit 16, it says you have to come back in. The necessary action to correct this violation, this is his wording. The necessary action to correct this violation is to submit a new application for a building permit and conditional use. We'll dispute the conditional use, but for the sake of doing what, as a backstop, we went in and applied for the building permit. And then we get denied because of a ruling that it was expired. You can't have your cake and eat it too. So if you're telling us to come back in and reapply for a building permit, you can't deny it because then you're saying the building permit's expired. There's no logic to this process. In terms of bias, I think my record is adequate on that. I think it's beyond bias, the fact that what's going on in this situation. And, you know, I would just submit tab 4, grounds for disqualification of an officer in a quasi-judicial proceeding. And then the other point, it just really got to me when, and I apologize for this gentleman, I don't remember your name, but when you said that when you looked at the subheading, and that's the 120, this is tab, it was up here, 23. She's using up my clock.
You're looking for tab 21.
I am, thank you, Mr. Chairman. To say that this is a Board of Adjustment and that isn't applicable to you, that's hogwash. That is so far outside the law that there's no way a court is going to say that that section does not apply to this group sitting here as a quasi judicial Board of Adjustment. You don't get, it doesn't have to say anything other than or other tribunal in construing the terms and provisions of the ordinance. That's you guys. This is your rules. You don't get to make it up. You don't have the discretion on that. I appreciate it that you've taken the time to listen to us, and I appreciate your patience. I know you have dealt with this issue over and over and over and over, and this has got to be getting old for you. I was a state's attorney for 26 years before I finally gave it up, and I know the issues, the difficulty that come with your decisions, because you got constituents on both sides. I, on behalf of Mr. Cutts, simply would ask that you look at the record, you look at the work that's done. The fact that somebody claims the mortality bin is not sufficient, that it isn't fixed, I don't think you're going to go out and pick it up. It's in the ground. It's there. They don't dispute that it existed prior to the 180 days. That it is enough. We didn't put a pig out there. We didn't do any of that stuff. He built the structure. Thank you again for your patience.
How much time is it?
40 seconds.
40 seconds left, if anyone would care to speak. That was quick.
I'm going to
No running.
split personality here. I want to voice as a Volun Township board member. I want to verify the fact that to the west there was a knoll that was muddier than hog snot, but you could come in. To the east was totally washed out. To the north, on the other side of the intersection of 447, washed out. On the south side was washed out also on 447. I want to speak in regards to Ray Up, a farmer, that work is very, I work in my sleep, for Pete's sake, anyhow, instead of sleeping. This planting season was a
Time.
whatever. Thank you for your time.
Thank you, sir. It's good effort, though. Okay, now we'll go ahead and move into 30 minutes for Board of Adjustment to ask questions and render a decision. Does anyone from the Board of Adjustment have any questions they'd like to ask? I guess I have a question for you, sir, about this change from, what is it, 2 barns to 1 barn?
Yes, sir.
Okay. Could you describe that more? And was there any documentation? It said permission was given from the zoning administrator, Mr. McGinnis. Do you have any documentation? Because that's a significant change, in my opinion, going from 1 barn to 2 barn. I mean, it changes a lot of things. Is there any okay with that? Any documentation you have that the county approved that?
Based upon what the testimony is, Mr. McGinnis, you got the right name?
Mr. McGinnis, yes.
Mr. McGinnis made the determination as the your zoning officer that it didn't change the footprint and it didn't increase the capacity of the facility. If he would have deemed that that was non-compliant, he would have then give my client a notice, and he would have had to amend the building permit. I'll grant that.
Okay.
But when your officer, and he was given a site plan. So, and I think that answers your question.
Sure, well, I asked because you don't have any documentation saying, we authorize, because he went through a conditional use process through the planning commission, and then the Board of Adjustment made a decision where it approved one barn, and then, or two barns, actually, and then he went from that two barns to one barn. Did the Board of Adjustment at that time rule on that, or planning commission, or was it just a verbal call from the zoning administrator, say, you're good to go? There's no paperwork whatsoever authorizing him to do that, from what I understand?
He didn't require any paperwork. He didn't submit anything.
Okay.
The only thing I would point out is we got a site plan that's missing. And that's perplexing to me. And I think that requires investigation.
Sure. Did you have something?
Yeah,
Haley?
Mr. Chairman, I can attest to part of the conversation, perhaps, that transpired between Mr. McGinnis and Mr. Cutts. I was not present for the actual conversation. Mr. McGinnis talked to me about it. He told me that the conversation had was Mr. Cutts requested a change from two barns to one, and that he told him he did not feel that was an issue because he was staying within the footprint. However, he told him it was a moot point because his permits were expired and he could not proceed with building. That was what was relayed to me from Mr. McGinnis regarding that conversation. He also said that Mr. Cutts responded and said, I don't acknowledge that they expire.
So I think this is bigger than just some of the other ones we had conditional use permit expire and building permits, and this, to me, is a whole different animal because it's not even what was approved. It's gone from, two barns to one barn, so it's a whole different type thing. All right, any other questions? Did you have any questions, Commissioner Healy or Lowe's?
I guess I don't have questions for him. I would probably request that, to me, it appears that that building permit number was altered. It looks to me like the number was issued probably in error, and Mr. Garrity perhaps fixed it. I guess to me, the complaint that the building permit posted, the number posted versus what's in the office, I will not take that in consideration in any decisions, I guess. I would ask that maybe we ignore that portion of the complaint.
Sir, I have another question for me, if you would.
Sure.
So how many total building permits and conditional use permits for these swine barns does your client and his family, how many have they gotten in the past two years? Do we have a number, like a rough estimate? Is it?
I'm coming in on the tail end, so I'm gonna have to defer
Is
to Jay.
it 2? Is it
That
15?
really
or
doesn't
what's?
have anything on the complaints on this,
Well,
Dan, but
I
I will answer your question.
Sure.
Because I have 6 building permits that I have available to me. 4 are under litigation for nurseries, and I have 1 operating barn.
Okay, so you have a total, what's your total number of nursery barns and finishing barns, total number, in your family? What's the total number that you have?
Well, it depends on what happens with the litigation, so
Well,
I
how many
can't
have you
answer
applied
that for you. That would be 7.
So it'd be 7. And what's the time frame when you got the first one to the last one?
I can't answer that.
Was
for
it a
you.
year? Was it a year and a half?
Oh, we
Was
started
it
this
2
in
years?
17. Let's put it that
Okay.
way.
I mean,
And
is
we're still
it
doing
realistic that you could expect to build 10 of these in a year? I mean, they said they
Is it
take.
realistic?
Yeah.
Yeah. You
You
could
think-
build 10 in a year. Not a problem.
Okay, thank you. Mr. Chow, could I ask you a question? Would you mind, sir? Could you explain your situation again on the one barn versus two barn situation? You sound like you have more information on that. Was the original designed for 2 and it went to 1, is that correct, or?
No, when he
Okay.
first applied for this location in January of 18 and subsequently hearings in February of 18, it was 1 barn. But he needed a variance to do that. And he couldn't get that variance, was asked to go do what he could to either redesign, relocate, work things out with Mr. Hanson, and he attempted to do that. It wasn't until September that we had another hearing regarding that, I believe September 11th or so, okay? And it was determined at that time, to come back, if we can't do 1, go ahead and look at 2 barns. In that process, in October, he said we could do 2 barns and move the location, so we have the 660 feet, and that's what's on the building permit 3431. Now, my thoughts on the number change is that's what the building permit was issued in January when he first applied, if you go sequentially, and Mr. Garrity just crossed it out and basically whited it out and reissued it in a different number. It wasn't nefarious, it was just keeping it sequential for the one that was actually approved. In fact, he just crossed out the 1 barn and they made 2 and had the dimensions for it.
Okay.
Okay? My concern about only going to 1 now is not that he talked to Mr. Guinness or not, I have no idea. It's not in the packet. But when you change the conditions of a conditional use permit, you get a different conditional use permit. And when he reapplied, if you will, in October, after being informed that he'd been expired, it's too late to necessarily reapply 4 months or at least 4 months after it's expired. You come in before that and work those details out. As this county had plenty of issues, and I agree. And that's why I believe our ordinance actually has a little bit of room for grace in there. You don't charge you again, just come in, we'll figure it out, whether it's a building permit, CUP, and we get it happening. But that's why on this application, it concerns me that it went from 1 to 2 and now back to 1, and what is it? We've dealt with this before in another location, and they're still building. Does that answer your question, sir?
Yes. Thank you.
But
Mr. Chairman, do I get a rebuttal given that?
Yeah, how much time do we have?
20.
Yep, come on up, that's fine.
You are the entity that has the zoning officer. And I appreciate Mr. Healy's statement for the record that your zoning officer confirmed what Mr. Cutts said. I appreciate that. Now, he may have said, and I have no idea, he may have said that the permit's expired, but that's a totally different decision. The fact is, you confirmed that he told Mr. Cutts that he didn't need to change the building permit. And I'm gonna take your word at it. You
Also
talk
said
to
that
your
he
zoning.
couldn't proceed.
Yeah, so, to me, that's the end of the discussion on that point. Thank you.
Originally, this first barn, it needed a variance, or it was gonna be in the floodplain, is that correct? Is that why it went from 1 to 2, the original application?
I think it was the setback distance.
Okay, so it needed either a variance or it was gonna be in the floodplain, is that correct?
It needed, there was a request, and I'm working from
Sure, sure.
There was a request for 2 variances. One
Okay.
was denied, one was granted. One
Okay.
was a right-of-way setback, that was granted.
Okay,
The other one was either a floodplain, property line. Yeah, it was a
Okay.
property line, it wasn't the
Okay.
floodplain. So the board denied because of the proximity to the property line. That was the 660 feet.
okay,
The facility that is being constructed is still in the same setback as approved,
and out of the floodplain.
and further out of the floodplain. Yeah. Thank you for the question,
All right,
Mr. Chairman.
thank you.
Is it the same style building?
Yes, basically, it's the same style building. It's not a,
Curtain style.
yeah, curtain style building. Yeah, with more fans, I would say, because it's a, it's a little different change, but it's still a curtain style natural vent barn.
Because I do believe in the conversation, along with that same conversation, Mr. McGinnis had said that your proposed to him was to go to a tunnel vent building at that
You know, I
location.
can't-
And that's what he said, yeah, you would be able to, in my opinion, except
Change
for
it
the
to
permits
that.
are expired.
It's the nomenclature as to what kind of building they call it, tunnel vent, natural vent, or, I'm not real familiar with that. So.
This is
it
your
could be a-
facility and your.
Yeah, but I understand how they're gonna build it and what it's gonna do, but the nomenclature of because there's all kinds of different buildings they build. But this would probably be considered a power vent barn or yeah, I mean, that's,
So
I don't,
it is
I'm
or
not
is
familiar.
not curtain side?
It has curtains on one side and fans on the other. So, what the nomenclature they call it in the industry, I can't answer that for you because I'm not familiar enough with exactly what they call certain barns that they build.
Okay.
So there's curtains on one side and fans on the other.
How does that affect the odor footprint and those other types of things that we had at the conditional use? And, that's my question, is because if you go through the conditional use process, we have all the documentation, it gets approved, and then something totally different is built that
And again,
it's
that's
all
why,
changed.
that's why I looked at this construction. It moves it out of the floodplain, which is a very important thing, and it moves it away from my neighbor. Now, it's not fantastically large amount, but it's another 100 feet, I think. I'd have to look at the site plan again to make sure. But both of those things improve the site plan for that building. So it moves it away, and hopefully, doing this, it will decrease the issues for my neighbor.
What are the dimensions of the building you've started?
Again, there's a lot of numbers floating around in my head, but I think it's 196 by 210. So it's the same square footage as the two 1200s. Doesn't change the square footage as far as building size. It still maintains the same square footage.
So how far are you away then from the neighbor's property line and then the right-of-way setback on these?
The right-of-way setback is 150 feet, because I got
Okay.
a variance for that.
Okay.
How far away am I from the neighbor?
Yeah, like are you 660 from the property line?
660.
Or how far are you from your neighbor? Because from what I understand, the neighbor wouldn't give it a variance.
Oh, yeah, I'm
So-
660 feet away from the property line for that neighbor, yes. I
Okay.
thought you meant the neighbor with the house. That's over a quarter mile.
No, that's fine. And then how far are you away then with, from the floodplain at this time?
That exact dimension, I would have to look at the engineer's as-built plans to answer that number for
Do
you.
you have an idea, 100 feet, 50 feet, less?
I'm gonna guess 75 feet away from the floodplain.
Mr. Chairman, can you tell how much further back you were from the original design? That would be,
Yeah, that would probably be a better question.
Sure.
I'm probably 25 to 30 feet further up the hill, up out of the floodplain.
Is that from the two barn design or
Yes,
from the one
from the
barn
two barn
design?
design. Putting those together with the same square footage allows us to move it out of the floodplain further.
Any questions from anyone else?
Yeah, Jay, before you sit down, make you do more work, where's your mortality been at in regards to where the barn is?
Where's the mortality? It is out along of the right-of-way to the south side of it, where it would have been for the two barns. Would have been the same place it would for the two barns. It's where we placed the other ones. It's out along the right-of-way, next to the driveway, so the rendering truck can come in and pick them up.
Were you permitted to build it within 75 feet of the right-of-way?
That's what the site plan showed, yes.
The orig-
They're under 4 feet or whatever they are.
It's a fence.
Yeah, it's a fence. So the mortality pins are, under that height for that 75-foot setback.
I don't have anything else.
Any other questions? How are we doing on time?
13.
I'm gonna just take some time to review some of these documents again.
Mr. Chairman, I'd like
Yep, we have time. Come on up.
Some of the question you've been asking, it goes to the point of when things change, the county's supposed to be notified. And I appreciate that Mr. Cutts went in and talked to Mr. McGinnis. Where's the documentation? Even going from, even the two site plan that was approved, that Exhibit 3 and 3A that is listed in the packet, is not in the packet. I don't know if it's in Mr. Vedder's office or not. So he says it's in accordance with the site plan. No one's seen the site plan. The only site plan that's been even offered was the original one barn. So that's that slope we go down with the temporary zoning administrator and all the confusion this summer. I get it. And I would like to offer this board and the county, there's a meeting that's gonna have to take place. We're gonna have to solve this, not just for Mr. Cutts, but for the other 3 or 4 applicants that are out there that we've had this issue with. And I would like to sit down with a couple commissioners, myself, a couple representatives, a couple representatives from them, and no lawyers, and let's figure out how we proceed. Let's approve something for these guys to build and use, so we know what's going on before we move forward. But right now, we're at a standstill. Because of issues like this, you can't answer questions about where it is, what size it is, how far it is from the floodplain. I've been out there and seen where he's put this building. It's right next to it, as far as I'm concerned, but I don't know the blue line on the map, okay? But there's one in your packet, but it's not drawn because we don't have a site plan with that floodplain on it. So that's our issue at this point. And I want to do everything I can as a citizen to help this board and the operators to move forward. Thank you.
How much time is left?
10.
Yep, 10 minutes.
There is a two barn one that is in their packet. It's Exhibit 3 of your packet. And it clearly shows that was out of the floodplain.
I'm sorry, what tab is that on?
This is not in mine,
Oh.
this is yours.
Packet 3, he
Okay,
said.
packet 3,
Well,
got
it
it.
says Exhibit 3. I don't know if that means it's packet.
Do you got a page or anything?
You didn't number yours. So
Was that the binder that you submitted for your, during
No,
your
that's a
application?
different one.
this is what you have
Oh,
online.
okay, I got you.
This is your,
I'll see if I can find it here.
so it's right after the unsigned building permit.
What does it look like again?
Here,
Is that this one?
yeah. Yeah,
Okay,
it's one that's
first
got-
packet, number 40, page 46.
I just wanted to clarify that was in there.
Yeah, thank you.
Time up.
No, I didn't mute my phone, sorry.
No. It's against the rules.
I know, just let me.
I think that's the rule of the computer, you gotta fight those.
Yeah.
We have 8 minutes.
Rob, I got a question for you on significant modifications like that. Does the zoning administrator have the ability to make large modifications like that after a conditional use permit has gone through the
Honestly,
process?
I don't know that. That's not
Okay.
before you today. That's not fair
Sure.
to either side to even address it today.
Okay.
And then the question is, did work commence within 180 days?
Okay.
Honestly, the question on variance and a conditional use expiring, that's really not before you either.
Sure.
You got the roads closing and you got work. Those are the two things that need to be addressed today.
Thank you.
Chairman,
Yes.
we're deliberating, and is it all right if I talk to Mr. Bevin?
How much time do we have left?
No, I just want to ask him a question on something totally different. I just didn't want to interrupt you.
Probably wait till we're done,
Okay.
if you wouldn't mind.
Sure.
6 minutes.
I'm just going through, we get a lot of documents here. I want to make sure I go through them all.
Because even on the original site plan, I'm not seeing mortality bins
It's
on
not
there.
there.
That's written.
Yep.
I'd be surprised that they'd be,
They haven't been on any of the other ones we got. What page are you on?
that 46.
Okay.
And 7.
Okay. Yeah, I don't see it on there either.
And I just would be surprised, and I know we're really looking at 180 days work and whatnot, but section 517 says there shall be no obstructions such as buildings, structures, grain bins, trees, wind breaks, baled ag products, or other objects within 50 feet of the right-of-way. I guess I'd be surprised if at any point a structure would be approved in the right-of-way or along the right-of-way.
Oh, yeah. Yeah, how much time we have?
May I comment?
220.
2 minutes, yep, yep. Please come on up.
And I appreciate your state's attorney's comment.
Mhm.
It appears that the board is considering issues that are not the issue that you are to address at this hearing. And we're trying to be open in terms of everything, but the focus is the 180 days.
With all due respect, though, that one of your arguments is that this structure had begun within the 180 days, and I guess if it's not part of the project, how do we?
It is part of the project. Your own minutes require that it be part of the project.
Is it on any of the site plans that you have, or?
I don't know.
Okay.
All I can tell you is that it's constructed.
What I'm saying, I guess what I'm saying is a fence placed along the right-of-way. I have a hard time making the gap to where a fence placed along the right-of-way is part of that project.
This isn't a fence. Fence wouldn't be.
Mr. Cutts just said it was a fence.
It's built, it's not a single one-sided structure. It's a four-sided structure. That can't be a fence. Is it made up of fence-like panels attached to posts? Yes, I think that's what Mr. Cutts is meaning. But you specified there had to be one.
Mm-hmm.
So he had to build it, and if he built it, it's work. That's all I'm.
Sure. Thank you.
Thank you.
Appreciate the info.
Yep. Yep. What do we have for time? 30 seconds?
20.
20 seconds.
Fence is artificially constructed barrier of any material or combination of materials erected to enclose, screen, or separate areas.
All right, time being up. We ready for our decision? Again, Mr. State's Attorney, it requires 4 votes from the Board of Adjustment to overturn the decision. Is that correct?
That is correct, and
Okay.
that's the only votes you have is for.
Somebody care to make a motion?
I'd move to overturn the decision by Mr. Gary Vetter regarding Mr. Cutts on permit 3431 based off the information and testimony heard today.
I have a motion to overturn. Is there a second?
Second.
I have a motion and a second. Further discussion. So a vote yes is to overturn, and a vote no would be to keep Mr. Vetter's decision upheld, correct?
Correct.
Okay, so a vote yes is to overturn, a vote no is to keep his decision, So everybody understand that? Okay, roll call vote, please.
Healy,
No.
Los,
No.
Swenson, Commsion.
No. Motion does not pass, decision is upheld. Entertain a motion to come out of Board of Adjustment and back into regular session.
So moved.
Second.
I have a motion and a second. Further discussion? All those in favor say aye.
Aye.
Opposed? We're back into regular session. Next item on the agenda, item number 7, public comment. Joe, would you see if there's any public comment, please? Thank you. We got 2 public comment, Mr. Ray Epp and Mr. Todd Wilkinson. Come on up, sir. Get your name for the record, and I'll give you 3 minutes. Welcome.
Ray up. It's so sad that there is no common in sense. Because sense tells me that the Cutzes put forth effort to substantiate the creation of a livestock facility. Just like this spring, every farmer in Yankton County put forth efforts. We had deadlines to meet. We could not meet them, but we kept fighting. Some of us were able to get some crops in and they washed out again. This is a prime example. We hear the term splitting hairs. I think there's some pretty fine hair splitting going on here because work has been established. Anybody with sense sees that. Anybody who has busted their tail to try and get a field planted, when more rain's coming, well, you say, damn it, I'm going to do it because that's what I'm on earth to do. Some of us are put on earth to raise livestock so other people can eat it. And these people are trying to look out for another generation or 2 or 3 with what they're doing. And they're splitting hairs. In the United States of America, the greatest country on earth, we're only going to get better. That next generation is going to do a better job than I'm doing, than their dad did. Because that's America. And we have a possibility of a denial of a future? What happened to life, liberty, and the pursuit of happiness? How happy is it for people to be sitting here arguing over sustainability in the greatest nation on this earth?
Thank you, sir. Next person, Todd Wilkinson is next. Welcome, sir. I'll give you 3 minutes.
Mr. Chairman, I put my name on there simply
Okay.
for one reason, and that is you've scheduled the next hearing on the 26th of December. I had no input on that. Frankly, my family gets 1 vacation a year, and you put that meeting without any input on the 26th of December, and we're going to be gone. And I just don't think that's fair.
I'm the one who scheduled that, and part of the concern is we've had a lot of difficulty scheduling a hearing for your client. It's gone back and forth, I don't know how many times. And so our advice when we talk to state's attorney is we schedule a hearing and we set the date and get it done. I didn't want to have it on that day either, but that's the date we had. The hearing notifications have already gone out. And
Have they
at this
gone
point, that's where we're sticking to.
I never got one.
Okay.
I never got a notification. I've been practicing law for 36, 37 years. And it is always common courtesy to talk to both parties and see if there's a problem with a date. And frankly, dropping something, the only time I got the opportunity to take a trip with my grandkids is on the 26th. And I think it kind of stinks. I mean, I told Mr. Vetter I'd agree to all sorts of different dates. You know, I'm coming from 3 hours away. I'm just asking a little consideration. Is that too much? I don't want to blow a Christmas vacation that's been planned for a month and a half. That's all I'm asking. A little consideration. I didn't.
What would your proposed date be?
You give me a date.
Because last time I checked, you guys wanted to go at the end of January, was it not?
I'll work to get, if I'm in my office, sir, I will work to rearrange my schedule. I mean,
At this point, I think our hands are tied. The notifications have already gone out. We have to give 10 days notification, so.
Actually, I don't believe your hands are tied because you've already continued this hearing because your notification was improper in the first place. The only reason I brought up the issue about the notice being improper, because if I didn't object and somebody else came in, they would say that the notice was defective, and then if I would have got a favorable ruling, my notice is out the window and we got to do it all over again. So, Mr. Chairman, I don't think this is fair. Would you want to drop something right on top and screw up your vacation?
I had to change my vacation around too for this hearing, and so as other commission members as well. I think it's important that we get this done, and I will discuss with our staff a possibility of an alternate date, and I'll let you know, but at this time, at least at this point, we're going to have the hearing on that date.
The other issue is, we already know.
And you're out of time too. Thank you.
That simply isn't fair.
What else did you want to add? I could give you an extra minute if you'd like.
Mr. Kettering is going to be gone, we assume.
And we don't know when he's going to be back. He may be out 6 months. He might not come back. I hope he does, but we don't know when he's coming back at this
I
point.
understand, but we have the writ. I just don't want to keep having to do these. You don't want
Sure.
to keep having to do these. If it's determined that there's bias from Mr. Swenson participating, we got to do this all over again because that's the remedy.
Right.
I just.
We will let you know.
A little courtesy.
All right. Thank you, sir. Anybody else care to make a public comment?
Yes.
Come on up, ma'am. State your name for the record, and I'll give you 3 minutes. Welcome.
My name is Lauren Nystrom, and I've lived in this county for 53 years, and I can tell you I have never been more embarrassed to live somewhere in my entire life. And I have someone very dear to me that fought horribly bad to get something passed that has tobacco-free in public areas. And Mr. Commsion, I wish you would abide by that. Thank you.
For tobacco free, what are you talking about?
I believe you're spitting tobacco.
My water bottle? The water bottle? Water bottle? It's not tobacco, so it's water. Thank you. Anybody else care to make a public comment at this time? I appreciate it. Entertain a motion to adjourn.
So moved.
Second.
I have a motion and a second. Further discussion? All those in favor say aye. Aye. Opposed? All right, thank you, everybody.